Well, ladies and gentlemen, thank you very much for coming back after coffee and the photo. It's very good to see you all smiling. It's a very, very good sign. I'm sure it's due to the quality of the first session, the opening session, as well as you're probably still smiling from the photo taking, so that's excellent. Now, we're here now for session 1, and the overview outline you will find on page number 2 of your program. In this session, we will look through the eyes of our expert at private international law and the role it does, it will, and or it should play in the 21st century. Now, this session will very much set the scene for this event. And like I'm sure you are keen to hear about the trends and the relevance of private international law nowadays and in the future. We are very interested to hear what insights you, the panel, can offer, and we are excited to witness an inspiring and enthusiastic discussion, possibly covering wide-ranging issues. And this is just a brief explanation, a recap of what you probably all know, but the session will be conducted what is called Davos style. So after some short introductory remarks and statements, there will be a moderated discussion among the panelists, and at some stage during the panel, our moderator, Lord Collins, will also invite you to become part of this discussion. And I encourage you to seize this unique opportunity to comment, to ask questions. But in the interest of time, if I may just ask you to keep any comment, question, or contribution concise, so that we have an utmost amount of those. But now, without any further ado, let me introduce you, Lord Collins, the moderator for session 1, who needs no further introduction than that. Thank you, Lord Collins.
Thank you. I hope this is working. Can I be heard? Yes? No? Yes? Good. It almost goes without saying that it's a great honor to be asked to attend this conference and to chair this session. We have some very distinguished speakers. Unfortunately, one of our speakers is not here, Professor Horacio Muir-Watt. Couldn't get here because of the French airstrike. So the mandatory rules of French employment law didn't seem to work. But we do have, of course, Professor Jürgen Basedow, who not only needs no introduction, but has already been given one. Professor Richard Fentiman from the University of Cambridge, a great expert on international litigation. And Professor Diego Fernández Arroyo, professor at Sciences Po in Paris, a distinguished scholar and practitioner, especially in the field of international arbitration and also in the emerging field of global governance, about which I'm sure we'll hear. It was only 3 years after the foundation of the Hague Conference that in 1896, Professor Dicey said that the growth of rules for the choice of law was the necessary result of the peaceful existence of independent nations combined with the prevalence of commercial intercourse. And he said the judges of every country are compelled by considerations of the most obvious convenience to exercise a choice of law, or in other words, to apply foreign laws. He also referred to the theoretical method which had been adopted by a body of continental writers, among whom by far the most distinguished was Savini, who considered private international law as constituting in some sense a worldwide common law, tacitly adopted by what were then called civilized nations, and that the fundamental principles of private international law could be ascertained by study and reflection. Dicey contrasted that approach with what he described as the positive method, followed by a whole body of authors, among whom Story was the most celebrated, and Dicey followed him. Those writers treated the rules of private international law in the main as part of the municipal law of any given country, for example, England or the United States or Italy, where they were enforced. I suspect that more than 120 years later, this division still exists between those who are looking for universal principles and those who prefer national solutions. We are in the middle of major activity in our field. I'll mention a few before I ask the speakers to contribute. Firstly, the Hague Conference Judgments Convention project, which, for the reasons Professor Basedow gave, is somewhat controversial, and I've joined in that controversy myself. The New American Law Institute restatements on the conflict of laws, on foreign relations, and on international arbitration. The EU has identified possible projects on property law, trusts, agency, corporations, arbitration, marriage, adoption. Fourthly, there are major implications for the wretched Brexit. Fifth, as Professor Basedow mentioned, the application of human rights law to issues which used to be regarded as exclusively in the realm of private international law, especially in child abduction cases. Sixth, the power of multinational developing jurisprudence on extraterritorial in the US Supreme Court, with the practical effect of eliminating judicial redress against multinational corporations for environmental damage and so on. Seventh, the implications of the internet in general and of the powers of Facebook, Amazon, and Google. Eighth, as also Professor Basedow mentioned, the need for a truly international insolvency law. Ninth, the emerging conflict of laws problems in international arbitration, which is also the subject of an ALI restatement draft. There's enough there, I think, for you to get your teeth into. And so what I'll do is I'll ask Professor Basedow to begin with his contribution.
Well, I have contributed already so much that I think it would perhaps be up to others to have a start and then respond to them. Let me just say one word about Savigny. Savigny wrote in the Germany of the 19th century, when there was no central state in Germany, but a huge number of very small, well, it's difficult to call them states, some cities, some sovereign territories, and so on. And they had no developed legal system. So that is why I think Savigny, who was at the same time a great Romanist, taking inspiration from Roman law, said, there is something universal in the background. Otherwise, I think he would have had difficulty with all these tiny princes there. Let me stop here. I think at present we agree very much on the fact that it is within the legislative power of every legislator to set the rules, and we try within the Hague Conference and other institutions to somehow harmonize them. But that does not mean that they exist without this harmonization. The Hague Conference is absolutely necessary for this harmonization, because otherwise private actors cannot build on some uniformity of outcome which they at least aspire to. Thank you.
I should say, please do not be alarmed by the fact that I've chosen to speak from the podium. There is, I think, an implication that at least half an hour's worth from me is going to be coming. Fear not, I'm going to stick to my brief and speak for no more than 10 minutes. I should, however, just begin by saying that I, too, am greatly honoured to have been invited to this important occasion, and I very much look forward, as I'm sure you do, to participating in shaping the work of the Hague Conference for the next 125 years. I must begin with a question, though it is only the first of many that I will be asking. What are the challenges facing private international law in the 21st century? Of course, we will each have our own personal menu of unresolved problems and new scenarios, some of which have been alluded to, issues and problems to which private international law must pay attention. But it seems to me that we need first to address a more fundamental question. Is the traditional technology of private international law fit for purpose at all? At the turn of the present century, when many of us ask the same question, I think the narrative went something like this. It's true that many of us questioned whether what we identified somewhat glibly as the challenge of globalization in the rather broad sense of that protean and rather meaningless term threatened the concepts and the methods of our subject. We identified some features of modernity which have been touched upon already today: technological connectivity, personal mobility, global markets, and burgeoning world trade. Of course, especially if you are an academic, the challenge of an existential threat is always exhilarating. And we debated eagerly the imminent demise of our subject. However, we all managed to snatch victory from the jaws of defeat. Generally, we concluded that the methodology of private international law was adaptable, that it was just a case of applying old concepts to new situations, even if people had to explain to us exactly what the internet was. By contrast, the issue that I want to address briefly now is not whether private international law can respond to changed circumstances. I'm sure that it can, nor whether the conceptual infrastructure of the subject is sound. Concepts are neutral, we can put them to work in any way we wish. Rather, the question that I want to address is whether the account of the subject offered by those of us who profess it and practice it is sound. Do we tell the right story? Of course, we could have asked this question any time in the last 125 years. What prompts the question now is the exponential increase in the volume of cross-border interaction as a product of globalization. I think that when private international law was a minority interest, the issues were less glaring. But it is now the interest of any consumer who buys online from a foreign seller whose server is in Vanuatu, or villagers in the Niger Delta whose livelihood is threatened by oil spills caused by the local subsidiary of a foreign multinational. And while it has always been a subject of concern in international commerce, increasingly complex corporate structures, interconnected markets, and the ease with which assets move across borders has given fresh life to cross-border litigation. So briefly, what problems are there in how we see our subject? First of all, private international law remains beset by abstraction. Even now, as we look at the subject, we witness a world of tensions, antinomies, and contradictions, created as much, I think, for the classroom or the doctoral thesis. So unilateralism vies with multilateralism, certainty does battle with flexibility, all presided over by the false idol of uniformity. The challenge, first of all, is to dispense with this heaven of legal concepts, to enlist Jürgen's phrase, and to recognize some realities. It could be said, of course, that these are just devices to help us understand the subject, but the image of these conceptual tectonic plates colliding with each other gives the paralyzing impression of a subject locked in crisis, not capable of forward momentum. It ignores the fact that the issue is not about competing goals, but about achieving the right solution to each problem. It's not, for example, that discretion is always good or always bad, or that unilateralism is an unadulterated evil. It just depends on the context. We may not want judicial discretion in matters of marriage, but it is essential to choice of law in tort. Secondly, the fundamental assumption underlying the choice of law process is false, or at least our expectations of that process are inflated. It is not a new point to say that the choice of law process is potentially undermined by the difficulty of establishing foreign law in national courts, an issue which the Hague Conference bravely sought to address. a challenge which is surprisingly often ignored, perhaps because the implications for our subject are too alarming. It's easy to meet this accusation with pragmatism, the accusation that we cannot properly apply foreign laws in our courts. In the common law world, for example, we can retreat to the principle that the proof of foreign law is evidential and state with relief that the only measure of success is whether a finding on foreign law coheres with the evidence. But this is unconvincing. Why devise elaborate choice of law rules if it is only by chance that foreign law will be correctly applied? And how can we say that the matter is purely procedural when the rights and liabilities of the parties are at stake? It's not to say that this problem robs the choice of law process of all point, but it reminds us of its limitations, and it identifies a job still to be done, addressing the foreign law problem. Third, uniformity is a mirage. This is true in several distinct ways. First of all, uniformity of result in choice of law is, of course, long discredited. Clearly, whatever uniformity may exist when choice of law rules are harmonized, as by the Hague Conference, normative uniformity, if you will, and however much non-uniformity may be avoided by minimizing resort to the lex fori, uniformity of result is undermined. It is undermined because the context of real-life litigation, and so the context of private international law, inevitably differs between states in relation to procedure, cost, efficiency, all the elements which inform intelligent forum shopping. And it is undermined, again, by the realities of trying to establish one country's laws in another country's courts. Again, private international law is compartmentalized, not unified. Different legal departments are distinct. Private international law in family cases begs fundamental questions and warrants different answers from private international law in commercial cases. Arguably, private international law should not be done by people called private international lawyers, but by family lawyers, tort lawyers, commercial lawyers, and so on. It follows that the values of private international law are localized. Following from this compartmentalization, the values and imperatives of private international law are those of the specific area to which the methodology is applied. If I may take a particular example, in relation to commercial conflict of laws, the objective is to assess or to allow the assessment and mitigation of commercial risk, thereby allowing the proper pricing of transactions. Finally, and I hesitate to say this in the context of this particular gathering, but private international law is inherently multilateral. Different legal systems legitimately differ in their approaches, each rooted in history and a distinct conceptual infrastructure. Not least, they differ in their perception of the judicial role, which, as we know, creates the opposition between discretionary and rule-based approaches, which causes such difficulty for the harmonization of private international law. In addition, there are structural reasons why a high degree of subsidiarity in favor of national law is inherent in private international law, which in a sense makes this a peculiarly difficult terrain for harmonization. That is to say, the procedural infrastructure of different systems necessarily differ, and mandatory rules and public policy have a powerful and legitimate role to play. Importantly, moreover, the complexity of the fact situations which generate private international law issues demands that a high degree of discretion, or at least evaluation by the judge, is required, with the consequence that uniformity is undermined, or at least uniformity of result. As this suggests, before we turn our mind to the substantive problems that we face, not something which I will do, but this may occur later in the conversation, we must first be sure that the story we tell about our subject is the right one. I must stress that the problems that exist with the current narrative do not consign private international law to the history books, a failed experiment in global ordering. But the context of private international law and its reality must be understood if it's to do its work. As we have heard already this morning, today, it is messy, not ordered, it is imperfect, not ideal, and it cannot supply all the answers. Importantly, in connection with the work of the Hague Conference, this is not to suggest that the conference's core business, private international law, is flawed or redundant, nor is harmonization in private international law subverted. but it shows that we need a proper understanding of private international law if the task of the Hague Conference is to succeed. I am conscious that all this is to rob the subject of its more utopian aspirations, but only if we appreciate its weaknesses do we appreciate its strength.
Okay, I think it's okay. Thank you very much for giving me the floor. I had thought in several options to share with you, and according to the several options, and my idea was according to the content of Professor Basedow's introductory lecture and Richard's intervention, I selected one of that possibilities, and that possibility is an idea that maybe some of you think is provocative, but it is not my intention. But if you think that it's provocative, I will assume the consequences. The idea is try to challenge, and maybe challenge is a pretentious word, challenge to notion of private international law focused only in state. This vision, state-centric vision of private international law. And I think there are many elements to comment about this, but I will try to just to mention a few, and maybe we have time to discuss about it later on in this session and in the following days. When I said challenge this state-centric vision of private international law, I'm thinking of several things. In particular, we are always thinking in the state or states as the only lawmaker, and a state as the only adjudicator. And that is the traditional view in private international law, and that is still the prevailing view, in particular in some part of the world, for example, in the European Union. And I think there are, on the one hand, there are many data undermining this traditional assumption. And on the other hand, there are some trends which shows another possibilities for private international law. And that is, I'm talking in general, but maybe several of these trends, you can recognize them in the current work of the Hague Conference and other international organizations, and maybe in the future work as a possibility. When I said this assumption is no longer valid, this assumption of the state as only lawmaker and only adjudicator, I am not saying that the state is not important. Of course, the state is important, and there is clearly the case that the state lawmakers are still making laws, in particular on private international law issues, and state courts are still adjudicating private international law cases. That is out of discussion. And when I talk about states, I am talking also about international organizations, which are formed by states, the only members of international organizations dealing with the elaboration of international rules, private international rules, or assimilated, are based on state membership. And there are many factors. I will not elaborate on each of them, but I am ready to discuss about it. But there are many factors that shows that
the general assumption is being undermined. And let me mention some of them. First of all, and it's quite clear, have the proliferation of international instruments, for example, made by the Hague Conference. And in many occasions, cases are not adjudicated upon the application of domestic law, but the application of international treaties, directly or indirectly, because in many cases when we apply domestic law, for example, if we apply the excellent Paraguayan law on international contracts, actually we are applying the Hague principles of international, the law applicable on international contracts, which inspired the domestic law. Secondly, of course, supranational integration, and already Professor Basedow has already talked about the implications, many implications of the European integration from private international law. Another element is, of course, globalization features, in particular economic, financial globalization, social globalization, in particular massive migrations, technological issues, communication, transport, etc. Another point also mentioned by Jürgen some minutes ago was what I call the human rightization of private law relationships. And it's not at all an European problem of European worries. It is not only a matter of daily application, a daily problematization in other continents, namely in my continent, in the Americas, and in particular in Latin America, but also it's a matter of cross-continental issues. And there are many cases in which claimants are or plaintiffs are in a continent and responder in another continent, and the solution or the no solution for the issue, or the several issues raised by claimants, is based on human rights considerations. Another point is, of course, the proliferation of non-national rules, standards, non-national legal orders, and finally, I can mention the rise of private adjudication, not only arbitration, but other means of private adjudication. So, actually, the state is very important. The state is the member of the international organization. The state is the key actor, but there are other many actors there as lawmakers, as adjudicators, and in particular as stakeholders. So we need to focus, I think, there was that could be the first interim conclusion. We need a private international law more focused in non-state actors. The second element I had announced is some trends, some answers to this situation. And I am not pretending that these trends are new, far too new. I had the chance to work for a long time with Professor Fritz Jünger. And Professor Fritz, one of the things he always repeated was, if someone tells you that he has a new doctrine or a new theory in law, you must be, maybe this is not the right person to talk with. And so I will not provide, unfortunately I don't have any new idea, but I will try just to mention what I see in the functioning of private international law. The first one is quite clear, is the shift of the X, or the focus in private international law as a content. So private international law taken as a matter of applicable law or choice of law is not longer the center of private international law. We can say that is not the most important thing in private international law. The shift from that into recognition and enforcement, jurisdiction, procedural issues, non-judicial dispute settlement, and cooperation in particular is quite clear. Second answer, and I have only 4, don't be afraid, is a shift or shows a shift in methodology, and a shift from localization to substantial justice. This is a kind of, we can call this a materialization. It's not a new word, but I think it is quite different now than it used to be presented some time ago. Materialization has been presented as an option for the selection of the law applicable, so the selection oriented by the result, or as a general methodology that was not very successful, but we all of us know the better law approach in the selection of the applicable law. But I think currently the issue is rather dealing with a notion of private international law taken as an instrument of global governance. And in this perspective, it not only covers applicable law, but also all the other sectors or areas of private international law. And it is not just blah blah. In the global governance discourse, there are much blah blah, and I totally agree with that. But in the essence, I think there are many tangible elements. Please think about the decision some months ago of the London Court of Appeal, and my colleagues in the podium can maybe refer to my accuracy than me, in the case Vedanta. Vedanta, Zambian case, and the idea of the parent company's duty of care in relation to overseas operation of a subsidiary. This case was a parent company in England, subsidiary in Zambia. The third avenue, and related with us, is a shift in the basis or the rationale of the jurisdiction. Traditionally, we took jurisdiction as a power, as an exclusive power, and for that reason, is still, as Jürgen Basedow pointed rightly out, it's still very difficult to think in a unification of rules of jurisdictions, except for some very specific areas. But what we are seeing now is a rationale of jurisdiction more directed to access to justice. So it's more a function than a power, and is centered in granting access to justice. And access to justice in the adjudication of the case and in the enforcement of the decision. I mean, if we take seriously that access to justice is a fundamental right, that must impact not only on jurisdiction, but also in recognition and enforcement. And the last trend is, I think, an increasing relationship between private international law and public international law. I will not elaborate on this, but there are many examples on this. So just to finish my first intervention, and maybe this can deal with the work of the Hague Conference or the HCCH, as it's mentioned in this conference. There are at least two issues to think about. One was already mentioned by Richard Fentiman about the goal of unification. In discussions I had before this conference with my friend Ignacio Goicoechea, who is the Mr. Private International Law in Latin America, we know like this. We talk about the Article 1 of the statute of the Hague Conference. And if you saw this article, they say that the goal or the purpose of the Hague Conference is the unification of private international law. I am not saying that we need to reform the statute, but it's crystal clear that the same Hague Conference has been violating the first article of its statute for a long while. So because there is not just a matter to unify private international law, but when the Hague Conference works, in my opinion, rightly, in the construction and in the consolidation of a network of judges, in particular was made for the child adoption cases. This is not unification, but is at least as important for private international law as the unification of private international law rules. And the second point is, again, the participation of non-state actors. I saw a document, an internal document of the Hague Conference showing some kind of reluctance to open, really broadly open to non-state actors in matter of legislation. I think it's a thing to take carefully, but with really an open spirit, because the idea that states alone or in an international organization can synthesize all the possible views on the current problem of private international law is a chimera. It's not possible. We need to rely on other actors who are maybe interested, maybe they have an agenda, but we know the agenda, and we can discuss openly about the pros and cons of the instruments we can elaborate within the conference. Thank you.
I understand my mic is broken. Is that right? Is it working? I don't know. Can I be heard at the back? Hands up at the back if you can hear me reasonably well. Fine. It seems to be all right. Thank you. I now have two mics. What I propose to do, I'm told this, as you said, as we heard before, this is Davos style. I had no idea what Davos style was until this afternoon. I still don't really understand. What I'm going to do is to ask one question of my fellow panelists, then I'll ask them to briefly comment on their respective contributions, and then I'll throw it open for comments and questions from the floor. The question I have is this. Since the 19th century, all the books on private international law, both in civil law countries and common law countries, have dealt with substantially the same questions: jurisdiction, status, contract, tort, recognition of foreign judgments. There have been slight differences. In civil law countries, they often deal with nationality, which is absent from the common law books, but basically they have the same structure. My question is really, today, is that structure adequate to deal with modern international problems? Or to put it differently, has the traditional private international law just become a small corner of international private law? And do we have to think about the subject in much wider terms than the traditional categories?
I guess if you had asked Clive Schmidhoff many years ago this question, he would have said, the world can live without private international law. We are doing everything with international commercial transactions, and I think the truth in that is that in various parts of international legal relations, standard forms, negotiated forms deal with the major risks of it. But then, even in those fields where arbitration is very, very common, every now and then we have a case which comes to the courts because the losing party does not believe into the right solution by the arbitration panel. So I consider this as one element of the growing significance of party autonomy. In many fields, party autonomy is 99% adequate to the problems that we have. In other areas, it is less so. When it comes to assessing the proprietary rights or so, we would not like to give very much confidence to what parties have agreed upon without the knowledge of third persons. In my Hague course, I have advocated to increase the significance of party autonomy. But I still would not believe that this is a 100% solution. Perhaps in future Hague instruments, party autonomy can increase in significance, but it is not good for all, especially because in many situations the parties do not think of making a choice. Or third persons are affected. Or there is an imbalance between strong party and a weak party. So party autonomy needs some correction.
Thank you. I should start by saying that I thought Davos style meant we were going to be sitting on bar stools. I was actually very relieved to discover that was not going to be the case. In answer to the question put by Lord Collins, I think the first point to make is I still think there is a need for a definitive treatise on the conflict of laws, which covers all aspects of the subject. So let me get that out of the way immediately. I think the answer to your question is, and it's consistent with the point I was making earlier, is that we are, I think, moving towards a subdivided subject. I mean, there are bits of tort law, bits of family law, bits of civil procedure which have foreign elements, and so on. So, for example, if one were writing a book which focused on, say, international commercial litigation, then clearly the balance would be very different from a traditional treatise on private international law, because almost all of it, at least if you're talking about English law, will be concerned with interlocutory applications, it will be concerned with jurisdiction and injunctive relief and so on. Almost none of it would be concerned with choice of law, except insofar as choice of law issues might impact on issues of jurisdiction. So I think it just rather depends on the area that you're focusing on.
I understood your question as if it's still valid to translate private categories into private international law, as torts, contracts, family. And I think that is still valid, but only partially, because that idea responds to a view that private international law is just private law with foreign elements. I'm not saying that that's not clear, but I think that is just a part of the general picture. And I think, given the fact that we have not much time, in particular for the students present here, I refer to the inaugural lecture in the Requel de Cours, the collected courses of the Hague Academy, delivered by Hans van Loon. I use that in my courses, and the students loved it. And it's a right explanation what private international law assumed as internationalization of the local private law is only a part of private international law, of current private international law.
So that's a roundup of some of your thoughts on our discussion, and then I'll throw it open to the floor. That's about it.
What do you expect me to do?
I thought you just came back from Davos. Sorry.
Wrap up.
Yes.
Well, my view on private international law is that the starting point of all analysis is the divergence of legal systems of private law in the various countries, and we have to find an answer to that. That part of the narrative is right, and then we can proceed. The traditional method has been one of allocation of jurisdiction and applicable law, subsequent recognition of judgments. I personally would give greater weight to party autonomy and to constructions in that context.
Thank you. I wonder if I can just pick up on something which Diego said. I agree with much of it, which is unfortunate because my role, I think, is to disagree with you. But I'm actually finding myself.
I was expecting that.
Supporting something that you've said. I mean, I was very struck by the comment that you made in relation to jurisdiction. I mean, I'm not putting words in your mouth, but I mean, as I understood it, that the traditional categories of jurisdictional connection were no longer apt or even being ignored. That's to say, wider considerations about access to justice, for example, should be an issue. So we don't just look at technicalities of is there a jurisdictional connection with our country in the normal sense. We have to ask the question, if we opened the door to this case, would that be a good thing in terms of outcome because we're encouraging access to justice or some wider goal? I took that. Yeah, okay. If that's the case, then I'm very struck by a case that was decided in England. I'm not being parochial about this, I hope. I'm simply making the point that if a phenomenon is evident at first instance in the commercial court in London, you know it really is a phenomenon. I think there is at least one case, and there are others, where the point you've made is illustrated in a very fascinating way. An issue that we have in English law concerns the problem of deciding when a court should exercise jurisdiction to grant a freezing injunction in support of foreign proceedings. Now, the assumption here is that the English court would not have jurisdiction over any substantive proceedings, so the claim for relief is entirely freestanding. Now, a question arises about what jurisdictional connection is appropriate in a situation where you don't have jurisdiction over the substance of the dispute. And I think until recently, I would have said, well, it could be the presence of the defendant's assets in the jurisdiction, or actually more convincingly, the presence of the defendant or the defendant's agent in the jurisdiction, because that is a traditional personal connection. There is at least one case in our commercial court where our court accepted jurisdiction to grant this remedy, a worldwide freezing injunction, in a situation where the defendant had no assets in England. Necessarily, there were no substantive proceedings in England. And in addition, the defendant had no presence in England. And if you ask yourself the question, on what possible basis could the court have done that, it's very difficult to find an answer, not least because the judge herself, I think, found it difficult to articulate what was, after all, a new concept in a way. But if you look hard, I think what underlies that dispute and underlies the decision is a notion that it would have been profoundly unjust to the defendant, it would have been unjust to the claimant if it were denied this remedy, because it would render all substantive legal proceedings against the defendant worthless. Equally, it could hardly be unjust to the defendant, because although these jurisdictional connections were not present, there were various ways in which the defendant had indicated that it was, in a general sense, happy to litigate in England, but equally it was very obvious that the defendant had escaped the normal jurisdictional connections deliberately because it knew what they were. So it moved its assets out of the jurisdiction and it made sure it had no connection with England. I simply cite this as being a very, very specific example of exactly what I think you're talking about. That's to say that we're moving from a, if only in this small area, from a very traditional view of jurisdictional connection to a wider sort of result-orientated view.
Yeah, I was referring to those cases, but it's not just England specificity, and I think the English specificity. I think there are in many countries we can see the same, or at least the same worries, irrespectively of the final outcome of each decision. But at least courts are asking themselves that if the traditional grounds of jurisdiction are enough in particular cases. For example, in the American Association of Private International Law, which is mostly Latin American, but I'm to represent all scholars and other actors in the Americas, we have elaborated with a very broad participation principles on transnational access to justice. And one of the things we are, or two things I would like to stress of that, I will come back with this principle on my next participation tomorrow, but there are 2 points related with this, we're stressing in those principles. One is the fact that we can consider, it's just maybe the time to consider a ground of jurisdiction, a kind of particular ground of jurisdiction based on violation of human rights or violation of common goods. For example, attempt against the environment, for example. And that is already raised in many cases around the globe. And the second point, I insist with this, even if I already mentioned at the end of my intervention, my first intervention, is the consequence that the recognition of the fundamental right to have access to justice should have on recognition and enforcement. I mean, in a country which says to have fundamental right of access to justice as a valid, as a granted fundamental right, it is difficult to understand why that state treats recognition and enforcement as an exception, and not as the general rule. So conversely, or in other words, if one state pretends to grant access to justice, that state accordingly must take recognition and enforcement of foreign decisions as the general rule, and only escape of that obligation in particular cases.
Just one point arising out of what Richard said. Am I on mic? Yes? Oddly, it was in fact the Brussels Convention which was the first to establish that courts could cooperate with each other in granting interlocutory relief, provisional measures, when another court had jurisdiction over the merits. And in fact, it was common law courts which were very slow to do this, not only the House of Lords, but also the Privy Council on an appeal from Hong Kong. And it was only the legislature that had to step in to remedy a defect which had really been caused by the easy transfer of money which occurred with the abolition of exchange controls in many countries from the 1970s onwards. So that was an example where the courts were slow to act, in fact, and although it seems that more recently they've been much more activist. So there is sometimes a contrast between the inability of courts to deal with things and the ability, but very often not often used, the ability of the legislature to deal with social or economic ills. Now with that, I think it's time for me to throw the discussion open. Is there a roving mic? There it is. And so if you put your hand up and identify yourself before you make your contribution, and if contributions could be kept relatively brief, that would certainly be helpful. So are there any takers for the first slot, always the trickiest one?
Hello, it's okay. So if the prime object is access to justice, and if that jurisdiction exercised against a defendant who has no assets in that country, was such a jurisdiction ever exercised? And if exercised, was it for any benefit to the plaintiff? Because this is my question.
In the example that I was
Yes,
using,
yes.
well, I think, it's a very complex case, I should say, if I can hide behind that initial defense. I mean, I think the point is the presence of assets is not going to be an issue in the English system, in the common law system, where this form of relief is equitable, and the way that you enforce it is by means of an order for contempt against the individual who has disobeyed the order. What was interesting about that is that the judge made the point, and this was really one of the points that I was making, that the defendant, who was a natural person, an individual, had said that he had absolutely no intention of coming to the jurisdiction. And of course, she took that as being his way of saying, I'm not going to put myself in a position where it can be enforced. But she said she thought it was very unlikely that he would adhere to that, and there was certainly a possibility that he would. So I think the point was addressed. I think it still felt worthwhile making the order on that basis.
But suppose there is agent of that defendant in the country where the jurisdiction has been exercised, and that agent doesn't have his own personal assets, or something of his principal. Still, that jurisdiction can be exercised because the agent is there. But
well, I think you're going back to the point I made about the traditional basis of this jurisdiction. I mean, I think the point is that there is as Lord Collins knows better than I, because he was the first person to write about the case of Duvalier. In English law, it does appear to be the case that even if the defendant is not present in the jurisdiction, if there is within the jurisdiction a defendant who is not simply an agent, I use that word slightly loosely, but is someone who actually has knowledge and control of the defendant's assets and is, in fact, the manager of the defendant's assets, then that, in that particular case, is a sufficient basis. It's not merely having an agent. I mean, merely because you had a solicitor, for example, or even a commercial agent would not be sufficient.
thank you very much. I am a judge from Pakistan, the Supreme Court. Yes. Thank you very much.
My name is Martina Pollock. I'm ambassador of the Republic of Poland to the Netherlands, and in my previous life, I used to lecture on private international law in the Jagiellonian University in Krakow. 125 years ago, Tobias Michael Karl Asser had idea of having one convention, very short, and covering all aspects of private international law. I think Professor Fentiman would call it utopian approach. And after the time elapsed, we are somewhere totally elsewhere where probably Asser wishes us to be. So we have decent amount, really important level of unification of the private international law, but at the same time, private international law has been scattered. Listening to Professor Fentiman, I can feel that he somehow sympathizes with the disadvantages, saying weaknesses are strengths. At the same time, reading some German colleagues, I can see increasing sympathy of going back to general principles, having like Rome 0 regulation. And I would like to ask especially panelists, Professor Basedow and Professor Fentiman, perhaps they can personalize the continental and common law approach to conflict of laws. So will 21st century be the age when we will go back to general principles which allow us to cope with challenges and opportunities in increasingly connected world, or it will be a century in which we will continue with piecemeal legislation on conflict of laws. What it will be. Thank you.
Jürgen, would you like to comment?
I have myself been very much opposed to a Rome Zero regulation at the present time. Although there are general issues. I mean, if you regulate choice of law in Rome I in a certain way, and in a different way in Rome II, and in Rome III again in a different way, with regard to the point in time, to the formalities, and so on, there must be something more than just the political coincidence of majorities that exist at the moment. But I think the general part is something that one can tackle once all the special parts have been regulated, or the majority of the special parts. But we are still far away from that. I mean, we don't have, at the level of the European Union, we don't have conflict laws on companies, we don't have conflict rules on proprietary rights, on marriage, and so on. Several, Lawrence Collins has mentioned several issues which are now perhaps on the agenda. I think time is not yet ripe, but we should start to do research about it and ask ourselves whether there is really a reason why in Rome II the choice must be explicit, whereas in Rome I it can be included. This is not really, to my understanding, it's not clear. And so I would rather push that back to a later stage. Maybe you would consider this a common law approach, but I think it's a cautious approach.
Yeah, I was not addressed by the question, but two things. One is I think, a motion of order. When we talk about, or my colleagues talk about Rome I and Brussels I and of the jargon, for those who are not familiar with European Union law, that's our instruments of European Union private international law. So it's not just name of train stations or something like this. And the other thing is not a motion of order, is claim for a more open view of the world outside or beyond Europe and the European Union. And in particular, regarding the question of the ambassador, in the Americas, almost 40 years ago, the conference, a specialized conference of the Organization of American States on Private International Law, adopted a convention on general rules of private international law. Actually, it's like Rome Zero, which is not existent, that is existent and is applied. It's not general part of private international law. It's just a rule of general notion of choice of law. It's only for choice of law. Even if in the case of this convention, Inter-American Convention of General Rules on Private International Law, the first article was quite pedagogical, which is a general call for all the states in the Americas to pay attention to the existence of a treaty applicable to the situation in order to avoid the automatic application of domestic law in the matter. So there's a general rule of priority of international law dealing with private international law issues over the application of domestic law. And that convention is not only applicable for cases related with contracting states, but is taken as a erga omnes convention. So in countries like, for example, Argentina, this convention is commonly applied to many cases which are not related to other contracting states.
Thank you. I suppose it depends what you mean by the general principles of private international law, on which we could have a lengthy discussion. I mean, if you attempted to have an instrument, whether it's one of the Romes, or perhaps we ought to detach it from the European context, or, if you have an instrument which simply sets out what we all know are the general principles of private international law that we learn in our conflicts courses, then it seems to me there's a risk it's simply vacuous. If you move down to a level of detail, and you, for example, ask the Hague Conference to come up with a statement of principles governing the design of its choice of law rules, then it seems to me once you do that, then you run the risk of endless fundamental disagreement about what they are. I think the main point, though, and it goes back to a point I made in my remarks, is that it does seem to me that if private international law is to work as an effective instrument, it has to be specific. I mean, I think the question is, what's our choice of law rule in tort? Or indeed, what's our choice of law rule for environmental torts? What's our choice of law rule for personal injury? I think that is the effective way to do it. So actually, I would definitely favour a bottom-up rather than a top-down approach as a matter of principle.
Yes, if we think about which have been the most successful international conventions, obviously views will differ on that, but immediately what comes to mind are the New York Convention on Recognition and Enforcement of Arbitral Awards, the Hague Evidence Convention, the Hague Service Convention, the Hague Abduction Convention, possibly with all its faults, Brussels I regulation, and with all their faults, Rome I and Rome II. Not easy to find in the field of private international law other conventions which have been so successful. Once you go outside, however you define private international law, once you go outside what was strictly private international law in the books, you have the Warsaw Convention, then into public international law, the Vienna Convention on Law of Treaties, the UN Convention on the Law of the Sea. There are some very, very successful international attempts at unification of one kind or another, but there have been many less successful, and of course many have been marred in hopeless and lengthy negotiations.
Yeah, my name is Richard Opon. I teach in Canada, but I'm from Ghana, and my question is for Diego. I definitely like the idea of envisioning jurisdiction from the perspective of access to justice, but underlying that idea of access to justice is denial of justice. So if you approach it from that perspective, then is there not the danger that by seeing jurisdiction rules from the perspective of access to justice, you end up taking all the high-value cases which would otherwise have been decided in developing countries, like the Niger Delta cases, like the Zambian case that you mentioned. You end up taking all those cases to the developed countries, and ultimately we end up underdeveloping their already underdeveloped legal systems. Because that is what has happened with international arbitration. You have all these high-value disputes which would have ended up in the courts of Ghana, Zambia, Nigeria. They are all being litigated in England or in Hong Kong or in some other developed jurisdiction. And we continue to indirectly underdevelop their legal systems. And then when we meet, we also, when it comes to enforcement of judgments, then we say that they are not independent, we will enforce their judgment. So we end up perpetuating a cycle. Is there not that danger?
I think it is. I think your question is a very pertinent one. But let me make these two comments. The first one is that developing countries or emerging countries, as we said nowadays, must actualize its legal systems and develop these legal systems. No country is condemned to have a system which is not able to deal with current issues and is not condemned to, does not respect the rule of law. And if you look at, for example, some reforms in Latin America, recent reforms in Latin American countries, you can be in favor or not. There are criticisms, but in particular the last three, Dominican Republic, Panama, and Argentina, the general reform of the private international law domestic system, I think are good enough in order to deal with those topics in order to keep litigation in those countries. The second remark is regarding the experience in arbitration. I think if arbitration, I totally agree with you that arbitration is going to some particular hoops. But that is because users are not very confident, not with the arbitrators, but they are not very confident with what will happen, as Basedow mentioned before, with the after litigation emerging of that arbitration in some countries. But that is also, is not a fatality of the design. At the beginning with arbitration, the hubs of arbitration were Paris, Geneva, London, New York, and now there are more than this, and the example of Hong Kong and Singapore are quite clear in this. 30 years ago, no one could think that there will be a very focus of arbitration disputes settled here in Hong Kong, and that is the case now. So I think it is a challenge for African countries to develop that, to develop credibility as to attract litigation and arbitration. But again, I come back to your question, to the beginning. I think the risk exists in the current framework.
Professor Fentiman spoke about the challenges of harmonizing private international law, but there's also an assumption among people, among the academics who are sort of immersed in the principles of fundamental principles of private international law, that the judiciary in developing countries are aware of these norms. But I think the HCCA can actually sort of contribute and sort of develop the law by formulating general principles. For example, in the field of applicable law, many especially where I come from in Sri Lanka, many of the judicial officers are unaware of the basic principles to adopt when foreign law is the applicable law. Like Professor Fentiman just mentioned, the fact that foreign law is a matter of evidence and the manner in which foreign law should be ascertained, particularly in an era where we are moving a lot into arbitration. We rely on non-lawyers to apply fundamental principles of foreign law as well. So therefore, I think the HCCA can actually assist in formulating and sort of having models for deriving principles of applicable law. And I was just wondering how far the HCCA has gone towards that, bearing in mind that these principles will be applied not only by judges, but also by arbitrators who are quite alien to these principles, and to what extent the models that are being looked at by the HCCA will facilitate the process of ascertaining foreign law in a very coherent manner.
For you, I think.
Well, okay, well, yes.
Let's focus.
Well, I was going to say, I'm not sure that I'm really entitled to speak for the Hague Conference, not least because the Secretary General is looking at me with a rather worried look on his face. I mean, I will make a general point. I mean, my understanding, actually, is that the Hague Conference is very sensitive to the particular issue that you described. That's to say, the importance of whatever one calls them, general principles, model laws, which can be transported and used elsewhere. I think I would say, now dodging the question slightly, I think what's very interesting about your question is that even as localized an institution as the American Law Institute, which of course is the body which creates the American restatements, has of course in some areas moved away from the tradition of merely restating US law into devising general principles, which I think can be of a wider application. So I think the general trend that you mentioned is certainly being picked up, and I think is certainly important.
Me? Yes, I did. Hi. Diego just now talked about being provocative, and being from Hong Kong, can I ask something extremely provocative? I don't think anyone has asked anything about Hong Kong being the host. The question I'm going to ask is about conflict of laws in the public law context. And it's getting a little bit political. As you know, in Hong Kong, the ultimate arbiter of the meaning of the basic law, the Constitution of Hong Kong, vests not in the judiciary of Hong Kong, but in a political organ in the People's Republic of China, known as the National People's Congress, operating under a completely different ideological regime. So, and we all know that in the civil/continental law context, the meaning of interpretation of law differs from what common lawyers understand to be an act of interpretation, in the sense that very often a continental act of interpretation of law can amount to amendment or elaboration or addition to an existing piece of law. And there have been controversial instances in the past where interpretations of the Hong Kong Basic Law had been commented on or perceived as amounting to de facto amendment of the Basic Law of Hong Kong. Now, when attempts are being made to challenge such interpretations in the courts of Hong Kong courts have responded by saying, you common lawyers are being arrogant, because who is to say that this piece of civil law style interpretation is not interpretation in the civil law sense? You need experts to tell us the limit of a civil law style interpretation. My question is, do you have any experience or insight as to the possible scope of private international law in the context of public law? For example, in the context I mentioned.
Thank you for the question. I think there are the particular situation of the Hong Kong, this particular political, general legal framework, is not the only one around the world. With different aspects, the same situation can be found in many legal orders, maybe the majority around the world, in which the judicial function is not really independent in the way of the necessity of relying with political control. Having said that, I think that is not necessarily against my proposal. The fact that there are many countries around the world in which the judicial function, and in particular what you call the interpretation of the law, is not only based on legal or judicial considerations, doesn't mean that we cannot have the expectation of movement for other bases for the rationale of the jurisdictional function. Of course, there are limits. The limits are sometimes very long in time and very large in space, but I think not at all those limits must make us renounce to more idealistic proposals.
I think one should not deal with this problem in a civil law, common law context or opposition. I could easily cite 10 or 12 judgments of the European Court of Justice where the Court of Justice has decided against what Germans would believe is the right answer. Yeah. So although in the context of the Brexit campaign, the European Court of Justice has been presented as something civil law, which, in the words of Lord Denning, with the continental law coming up, the estuaries or so, it is much more complicated. It is a court with one judge from every country, and I tell you that the differences in legal methodology, in the interpretation of statutes between the new member states in the east of Europe and the old member states in the west are sometimes wider than those between common law and civil law. The problem for Hong Kong is that there is no neutral body, no, let's say, a body which is respected by both Hong Kong and mainland China to interpret this. I think that's the problem, not common law, civil law.
Yeah. I don't think this. I think it was.
I'm from Wuhan University. My name is Xiao Yongping, and I have just one question and one comment. My question is, when we talk about the right of access to justice, we should know where the right comes from. It's from the public international law or the national constitutional law. Because in the other parts of the world, it's different from the European Union. Because European Union have the Convention on Human Rights, maybe it's provided by this public international. But in other parts, we should know where the right, the fundamental right of access to come from. It's from the public international law or constitutional. This is my question. And my comment is that when we talk about the rights of access to justice, I think we should in different relationship, when it is the relationship between the private and the government or litigation to the court, it is you have enough chance to go to the court or to arbitrate to dispute to settle your dispute. But another relationship, I think, if the relationship is between the two litigations, that's right, need the equal possibility for two private parties. So the private international should set up the proper jurisdiction rules to give the equal chance to private parties. So I think when we talk about the right of access to justice, if in different relationship between the private and the public or two private parties, it's different meaning, I think. So my question is first, if you gave me the answer. Thanks.
If I can start the ball rolling, but with just a personal view, I think the right of access to justice is a general principle of law, and it's inherent in the idea of justice. And so it's in England, it's the Magna Carta. In many countries, it's express provision in the Constitution. It's in the conventions and instruments on human rights. The real problem is what's the scope of the right in any individual case. I mean, tomorrow, for example, we've got a case in the Court of Final Appeal which is about access to justice in the context of whether a litigant in an administrative law case is entitled to a protective costs order to ensure that they don't have to pay the costs of the other party if they're unsuccessful. In public international law has a part to play in the question of the right of aliens to access to justice in a foreign country. Has many, many aspects, but I believe fundamentally it's inherent in the idea of justice and as a general principle of law.
A general principle of law, as pointed out in a resolution of the Institut de Droit International, whose reporter was Lord Collins. I fully agree with that.
Well, I'm told our time is up. Let me thank the panelists and let me ask you to give them thanks in the traditional way.
Well, distinguished panel, Lord Collins, Professor Fentiman, Professor Arroyo, Professor Basedow, well, thank you very much indeed for that inspiring and insightful discourse. Clearly, when I looked around the audience during this discussion, I could see that all participants greatly enjoyed this panel, which raised so many thought-provoking points, so many insights, and which so perfectly set the scene for the following 2 days. And I encourage all of you to reflect on and to continue to think about the issues and matters that we discussed here, because I think plenty of them will come back. And there's plenty of opportunity for that as well over the next 2 days, not only when we resume tomorrow morning, but also during our welcome reception, which will take place downstairs in the area where we had coffee beforehand, but also you can spill out into the gardens. And to that, I invite you now cordially. However, before we rise, again, a short housekeeping matter for tomorrow and Friday. And given the beautiful sunshine outside during the photo session today, inspired us to think that what we could do is to switch over to a more smart casual dress code for the next 2 days. So we add to the concept of the casual Friday also the concept of the casual Thursday, and we dress down in order to up the comfort. So thank you all very, very much for a great start to this global conference, and please join us for more discussions, but also for great networking opportunities downstairs over a cool beverage and some delectable morsels, and I will see you downstairs soon. Thank you very much.